Hello, everyone, and welcome to today's webinar, Complying with CASL and GDPR. My name is Kelly McNamee. I'm in charge of Customer Success Marketing for LexisNexis and will be your host for today's webinar. Before we begin, I have a few housekeeping items to review. The webinar is conducted in listen-only mode. In order to ask questions during today's webinar, please utilize the questions box in the GoToWebinar panel. We will save time at the end of today's presentation to address questions. We expect this webinar to last approximately 1 hour. We're recording today's session, and you'll receive a link along with a copy of the slides within a week. We have two special guests with us today. Julie Chapman, Head of Legal and Chief Privacy Officer for LexisNexis Canada, who leads the Canadian Legal Department of LexisNexis, and Mike Lamb, Global Chief Privacy Officer for the RELX Group, the London headquartered parent company of LexisNexis. You'll see the agenda here up on this screen. Julie, if you could go to the next screen. Perfect. And the first portion, I wanted to give you guys a heads up here. The first portion of today's webinar that's going to be covering CASL, this will be most relevant to our customers that are outside of Canada, just based on the level of knowledge that we'll be providing. And the second portion of today's webinar will cover what's known and what's still unknown about GDPR, and that part will be most relevant to our customers outside of the EU, again, based on the level of content that we'll be providing. First up today is Julie, and she's going to talk to us about CASL. So Julie, I'm going to go ahead and pass the webinar over to you. Thank you, Julie.
Thank you, Kelly. Good afternoon, everyone. Thanks for joining us today. I appreciate the introduction, and I won't delay getting started. So CASL, I don't know how many people on this call are familiar with it, but it is a short form for the Canadian anti-spam legislation. And before I jump into why we care about CASL, I'll give you a little bit of background in terms of why this is only recently relevant as opposed to something that's been going on for years. So CASL is legislation that was put in place in Canada. It came into force in July 2014, so pretty much exactly 3 years ago now. And the reason for it was because, like many of us, there were some complaints and some concerns that there was just too much email that people considered spam, and the government decided they should do something to stop that. And what ended up being put into place is actually, I would say, legislation that is more complex and broader than it needs to be to necessarily deal with spam. But in any event, we do have to comply with it, obviously, especially considering many of our clients are sophisticated and lawyers and are well aware of the legislation, at least in Canada. And the big difference about CASL compared to the old regime is that just like in the United States, where you can send emails to someone essentially until they tell you to stop, that was our old regime. In Canada, they switched that on its head and said, you can't send commercial messages to individuals in Canada unless you have their consent to do so. So it essentially flipped it from opt-out consent to opt-in consent. Moving on to why do we care about CASL? Because it impacts all aspects of our business where digital communication is used. So before I go back, before I go forward, in terms of the summary of the key changes in the Act that you need to be aware of, is that when I talk about digital communication, number one, that's not just email, although in many times when you're speaking of CASL, people are just referring to email requirements. But technically, it does apply to electronic messages sent by email, SMS, instant messaging, as well as social media in certain instances. And what it does, in terms of the changes that have had to take place within an organization to make sure you're compliant, is it's imposed a requirement that makes you more succinctly and accurately record unsubscribes, express consents, and implied consents. I will get to explaining more about what all that means. So what it does, in short, is it requires us to collect and record a lot more information about our digital communications with our customers. The other big reason that we need to care about it is because of the penalties, the potential penalties. As you can see from the chart that I'm showing here, and we're going to focus on spamming today. You'll see there's a list of new violations on the left-hand side of the screen, and some of them are, they're all included in CASL, but the biggest one, especially one that you would need to be aware of, is the spamming violation, and that's what we're going to talk about. But the penalties there are substantial. For individuals, it's $1 million per violation, and for businesses, $10 million per violation. And that's a regulatory fine. So that's not, damages in a lawsuit or anything like that. That's something that the government can impose on you if they've found that you've breached the act. So the next question is, does CASL apply? In Canada, it's a much simpler answer because, as you can see, the definition says CASL will apply to any commercial electronic messages where a computer located in Canada is used to send or receive or access the electronic message. So if you're located in Canada and you're sending the message to someone within Canada, you've been caught all three ways there. Now, if you're in the United States, you might actually have to take a step back and think about whether it is caught. So the other portion of that definition, as you can see, is that the only electronic messages that have to comply with CASL are commercial electronic messages. And commercial electronic messages are defined as any electronic message that encourages participation in a commercial activity. Now, you'll see I've listed some examples here. Catches quite a few of the things that you would assume would be commercial in nature. But a really important point to be made here is that in a lot of laws, potentially in other places in the world and under our old system, something was only commercial if the primary purpose of the message was promotional in nature, for example. Now, it doesn't have to be the primary purpose. It's if any purpose of that electronic message could be deemed to be promotional in nature, it's caught by CASL. So what that could mean, and what I often make note of to the sales and marketing people here in Canada, is if you're sending out a message and you're not necessarily trying to sell something or market anything, but you do have something, you're communicating with a customer in basically a transactional way, but there's something at the bottom of the email that says, maybe under your signature, for example, that says, check out interaction, new release, and here's some of the benefits of it. That, to me, turns the message from just a non-promotional, non-commercial electronic message to a commercial electronic message. And therefore you have to comply with the requirements of the Act. So here's just a couple of, a slide basically to show obvious examples of where you'd see it maybe in an email or an SMS text message, for example, something that's obviously a commercial message. But again, you always have to make sure that, even if this isn't the main part of the message, if it's a small component of the message, that's considered a commercial electronic message. So if you do ask the question, is it a commercial electronic message? Does CASL apply? Yes. Then what is required in order to comply with the Act? So these are the three components, main components. So you have to be sure that the intended receiver consents to the receipt of the email. And I'll explain to you how you can, the different ways that you can meet that requirement. Number two, the message includes prescribed information. And what the prescribed information is listed here. Basically, it identifies the person sending the message or the entity on whose behalf you are sending it, and provides a method where the recipient could readily contact the persons responsible for sending the message. So in essence, you need to include the company's contact information. So the name of the company, home address, email address, phone number, that sort of thing. That's the prescribed information. Number 3, and this is very important because this is the one where a few companies have been caught by the regulatory body because they've screwed up on this 3rd one. So the message has to have a working unsubscribe mechanism. Here's another slide that sort of brings that all together. You have to identify the company, you include your contact information, make sure that contact information as well stays accurate for a period of time after the message is sent. And if you're going to provide a link, for example, to Interaction's homepage where they can find the address there, make sure it actually directs them clearly to the address and doesn't make them dig around for it, because that's actually one of the requirements of the Act, is that you can't make anything overly burdensome for a customer, or a recipient, I should say. So now, on to the first component, which I mentioned of the 3 requirements. And this is ensuring that you have the consent of the recipient. So the gold standard of consent, as I mentioned, is if you have opt-in consent. That's the gold standard, express consent. So essentially what you have is a client who has gone to, the way we do it here in Canada, and there's various ways to do it, but the easiest one in Canada, right on the front of our center of our homepage, we have a little box that you can click that says, do you want to hear from us? Do you consent to receiving commercial electronic messages from LexisNexis? If you do, all they have to do is provide their email address, press click, and we've got it. Next is implied consent. So that's a situation where a relationship exists with a recipient, but they have not taken any express, proactive action to actually opt in to commercial electronic communications from your organization. And there are some exceptions, which I'll briefly touch on in a moment. So here's another chart, just to help you understand the difference between express consent and implied consent. And the biggest thing to note about express consent, and again, why it's the gold standard, is because it never expires. Someone says they want messages from you, then they've opted in only until or unless they decide to specifically opt out. So you can keep contacting them for however long you would like to. Whereas the big difference with implied consent is it's generally time limited. So in most cases, it's a period of 2 years after the event that starts the relationship. So one of the examples I'll give you, and I'm not entirely familiar with the way Interaction is sold, but in Canada, most of the legal and professional products that we sell are sold on a subscription basis. So if we have a client who has purchased a subscription to our, to Lexis Advance, for example, and that contract expires, July 1st, 2017, that means we can continue to contact them with commercial electronic messages for 2 years from that date, so until July 1st, 2019. Again, with the always caveat there, unless they specifically tell us not to, so unless they decide to unsubscribe within that time. And what the opportunity that implied consent sort of 2-year period that you have gives you an opportunity to try to have an individual provide their express consent during that time. So if you can actually get them to convert that implied consent to an express consent, then you're not time limited. And that's one of the biggest things to understand here is the interaction between the two. Some of the implied consents that are the most relevant to what we do as a business is obviously the existing business relationship, okay? So what I just talked about, if they already purchased something from us, we have an existing business relationship with them, we have implied consent. if we have an existing non-business relationship, though this generally applies to registered charities or volunteer work, things like that, associations. And the big one for us, number 3, in terms of dealing with our law firm clients especially, is that if you're able to go and get someone's email address off their firm website or their company's website, so you can essentially assume that they intended people to take that email address and use it to contact them, and you're contacting them about something that actually has to do with their business or their official capacity, you can go ahead and email them based on the implied consent rule. As long as, again, the important point there is that it has to have something to do with their business. And that middle part of this slide here is essential, and what's essentially caused us the most work as an organization to get in place tracking tools, because record keeping is the key here. The onus is on the organization sending the message to prove that they had the consent to do it. So therefore, all the things I'm using as examples, we have to have a tracking system for that. So if we do have, the regulatory body come and say, we've had a complaint, prove to me that you were able to send that email, that you had the consent of the recipient, we have to be able to do that. This is just a chart that I obtained from one of the larger law firms here in Canada, breaking it down in terms of, express and implied consent and the various options there. The one thing I want to briefly talk about on this slide, and then we can move on, is the right side of the slide, the exceptions to consent and the exceptions to both. So what that means is the top box, exceptions to the consent requirement that we talked about of CASL. That's when you don't need a recipient's consent to send them a message. But you do need to still include the prescribed information that I mentioned, essentially the company's contact information, and that working unsubscribe link. Those will still have to be on the message so they are able to unsubscribe if they would like to. But if you're dealing with things like quotes, so a customer sends you an email and says, I'd like a quote on this product, you can go ahead and reply to them. That's an you have their consent to do that, essentially. If someone's asking about an employment opportunity, so one of the big ones that does come up is if you're talking about an update to a product or warranty information, and telling them that the product is being delivered, for example. Those are things where you don't necessarily need their consent. Again, have the unsubscribe. The exceptions to both, meaning that you don't have to have consent and you don't have to have the unsubscribe. So essentially what it is an exception to the act. It's not really caught, are things that you can see on this list here, which I won't get too into because a lot of them don't necessarily apply to us. Now, proving compliance under CASL, I mentioned the onus is on us. This is why we need to have the systems in place to be able to prove it. And as you recall, the penalties are very high if you can't. So that was enough, obviously, in Canada for us to create our own system to track. And I mentioned this before, but I can't emphasize it enough. No matter what type of consent you have, the recipient can always tell you to stop contacting them. They can do that at any time, and if they do, you have to make sure you record that and put that into place. So stop contacting them within 10 days of their request. So in Canada, what are we doing to ensure compliance? It's a little more obvious here because what we had to do is just assume that all the emails that are going out are probably going to be caught by CASL, because as I told you, commercial is the commercial definition, commercial electronic message definition is very broad. So many things were caught that were coming from our sales team and our marketing team. So we've taken the position that we're assuming that we want it to be compliant with CASL. So on all our messages going out in our standard signature, we require employees to include the prescribed information, so the contact information, as well as that unsubscribe link. That's just required. Now, when you're talking about something from, coming from the US being sent potentially to someone in the US or into Canada, that's where you need to sort of look at it in a little more depth. And again, go through the practice of what I just described of determining whether or not you do need to include that information in the message. And what we have in Canada is what we describe as a CASL tool. And essentially it was our own IT department that when this law was coming into place back in 2013, we were aware of it. We actually created software that we refer to as a CASL tool, and that allows our employees to record the consents and as well to go in and do a search based on an email address in order to determine whether or not we can contact them. And we have every new employee that joins the organization trained on how to use that tool. And then obviously, especially the employees that are working in sales and marketing or anything else that is really customer facing, they get more extensive training and they have refresher training as well. We do actually have a couple of business units outside of Canada that have that are utilizing that tool in some way. They are organizations within the global RELX umbrella that deal with Canadian recipients on a regular basis. So that's why we had arranged that. Again, if you do have any, if you do feel like there might be a need there, there's something we can do to help, let me know. So I'm just, here was an example of what I said. So let's say a sales rep wants to email a prospect. Before they can do that, what we expect them to do is go into the CASL tool. They put in the email address, and if it pops up and it says go, you know, meaning you can contact them, then you can go ahead and do that. If it pops up saying no go, that means we have nothing in our system that tells them that we either have express or implied consent to email that person. So in that case, that's where you could try to find a way to do it. In terms of maybe you know that person works for a law firm, go to their law firm website, take a look. Is their email address there and you're going to be emailing them about something relevant to their business? Then you can take a screenshot of that web page showing their email address, upload it into the CASL tool, and it will automatically allow you to go ahead and contact them for a limited period of time. So again, just to recap the importance of this, before you press send, if you're dealing, especially, you know, if you're thinking this is a potential connection to a Canadian company or recipient here. Is it a commercial electronic message to a Canadian recipient? If yes, do you have implied or expressed consent? If it is a commercial electronic message, do you make sure you include the prescribed elements? Again, the proper identification, the unsubscribe mechanism, and the way we do that in Canada is to have a footer basically saved in our signature file of Outlook that you can just take and drop in there. Sorry. And sorry. So that is the end of my presentation.
Thank you so much, Julie. I'm going to pass control over to Mike, so bear with us for a moment while we switch over. So Mike, you should be receiving a notification, and it looks like we are successful. So Mike, I'd like to pass the control over to you to talk to us about GDPR.
Great, and thank you, Kelly, and thank you, Julie. We'll see some parallels, but certainly not complete, between what we talk about in the European Union and what Julie talked about in Canada. And I am going to talk about the new so-called GDPR data protection rules, but you'll find that this is very high level given the short time. And you also find that this is early in the process. We have firm GDPR rules that have been issued, and they have the effect of law. They take effect in May of 2018, but we're still waiting for a good deal of regulator guidance, either country by country regulators, or there are certain committees of all regulators. And we're also waiting for some parallel companion law to be finalized and put in place. So I'll sort of highlight that so you can keep an eye out for things, but we don't quite have the same firm set of rules that we have in Canada. As I say on this slide, the data privacy rules in the European Union are already very strict, and they're about to get much stricter with the GDPR, which is the General Data Protection Regulation. The current EU rules, and indeed the new ones, are based on a different approach than we see in the US and in a number of other jurisdictions. In the EU, privacy is a fundamental right, and it gives individuals significant control over personal data about them, even if that data is from public sources, public records, newspapers, online, and so forth. Privacy rules apply even if the data is not quote unquote private, it's very publicly known. The new rule, as I say here, takes effect May 25th. It will apply across the EU and the UK despite Brexit. And in contrast, it will apply as law when it takes effect. Today, European or EU data protection law is a directive that said, here are the principles that need to be followed. Then that was implemented country by country across the European Union, and that led to a great deal of variation. Laws in Germany, for example, are much stricter than the data protection laws today in the UK. And the GDPR is designed to create a uniformity. It allows some variations country by country, but not nearly as many. And then as I flag in this third line, it's an attention getter within our company and probably at most firms and companies. The fines are very high for violations under GDPR. It varies on the type of violation, but it can be up to the higher of 4% of global turnover, which is basically revenue, or 20 million euros, whichever is higher. And finally, it has broader impact. It's not just applying in the four corners of the European Union and the UK. It has some extraterritorial impact. And we'll turn right to that in sort of a why do you care slide. The question I pose here that you might have is, my firm's not in the European Union, why should I care? And there are three basic rules that might extend the GDPR rules to EU personal data that you have or hold outside of the EU. First, it applies generally to the processing of EU personal data if the firm is established in the EU. And that means located at its core, but it's read very broadly by the regulators and by the European courts. And if you have sales representatives in the EU or branch offices in the EU, you may well be established in the EU. There's a decision to be made, and certainly I'm not going to advise you, and there's no clean, clear rule, but that's a risk. And if you're established in the EU, then the GDPR will apply to the EU personal data you hold. Even if you're not established in the EU, it applies in two particular circumstances. This is set forth very clearly in the GDPR itself, in Article 3, for those who have a handy copy of a 150-page law. The first scenario where it applies is if a firm offers goods or services to data subjects in the EU. And that's sort of very carefully phrased. It's not going to be for anyone who has a website that gets access by a customer from the EU and they buy something. Offering requires some sort of affirmative, targeted marketing or seeking out of EU customers. And they take into account all the subjective context, such as what does the language say on your website? Does it talk about EU customers? Do you offer them the pages in language, in Portuguese or in Italian, those kind of things? That would be a sign that you're targeting those jurisdictions. And do you accept payment in pounds or euros, for example? But that could mean you're offering goods or services to data subjects in the EU. And then in terms of jurisdiction, if you do trigger it, that would probably only apply to those services, not to every service you have of any kind. But that's an area where certainly you'd be speaking with your counsel on exactly how it applies. The other nuance in this statement is it says offers goods or services to data subjects. Most of the advice that I have seen believes that excludes business to business or B2B offerings. Data subjects are the equivalent of consumers in sort of data protection language that's used generally in the EU. And so if you have a B2B offer to businesses or to law firms in the EU, arguably you would not trigger this leg of jurisdiction by how you offer. We're waiting for regulators to see if we're reading that appropriately or not, but that is the current language. The second trigger for firms not established in the EU to be under GDPR jurisdiction is if you're monitoring the behavior of EU data subjects that takes place in the EU. And clearly, if you offer, which some of our subsidiaries do, watch lists that monitor EU behavior, whether it's anti-money laundering or other types of terrorism watch lists, we're monitoring when we do that. But also, there's been regulatory guidance in April from the EU regulators that said just monitoring and tracking online and how people use your website, not in a diagnostic way perhaps, but in an actual individualized tracking way, that could be monitoring behavior of EU data subjects. We'll see if they apply it that strictly in practice. Now, quick headline here. May seems like a long ways away. Why don't we just wait for all the regulatory clarification to occur, and we'll apply it then. And the problem is that if it does apply to your business, there's no grace period after May. They figure this period when the statute's been published is the grace period. We're in it now. But also, if it applies, you have a whole series of regulatory compliance processes and procedures you might need to put in place, at least for the data to which it applies. And it's not necessarily just a little compliance overlay. It changes how you use data. So even if we don't have clarity on exactly how we can market with EU data, we can start to conform if we think the law complies. Now I'll touch on some basic concepts that are used, and I'll use them too, but I'll go through quickly. I don't want to spend too much time buried in the details. Personal data is anything that's identified or identifiable to a person. And that's a broad concept. It includes name, email, address, that type of thing, phone number. But also an IP address can be personal data if you can figure out the person that it's associated with. And that's one of the examples the law and the recitals give. And if you take the data and make it anonymous, truly anonymous, then it's no longer personal data. That's great. You can do a lot of studies and analysis with that. But if you keep a key to that data, where you can actually re-identify it, then it's not anonymous. It's called pseudonymous, and it's still personal data. And then also, just a couple of concepts you'll see in the law, and we'll use a couple of them today, is controllers are a type of firm that actually controls personal data, determines the purpose, and how we're going to process it, what you're going to do with it. Most of the data, when you're holding the data and using it, you're probably a controller. A processor is somebody who only can use the data at the direction of a controller. Like if you're using a cloud firm, the cloud firm is your processor. And there are different rules that apply to these types of firms, but they're both subject to the GDPR. Another concept that's important is processing. Processing in the EU today and under GDPR is anything you can do with personal data. Collect it, storage it, transfer it, use it, publish it. Anything is processing. And that's important in part because for any type of processing, you need a legal basis. And in the marketing setting, that's sometimes and often consent. We'll talk about the new consent rules, but there are other legal bases that I won't get into for the most part. One's called legitimate interest that I'll touch on, and other bases are necessary to perform a contract with the data subject or compliance with a legal obligation. Those are other alternative legal bases for processing. You always have to have one. So my preview here, if you're collecting and using EU personal data for marketing, you have to always identify and have a legal basis. This page I'm not going to go into. It's just to talk about there's a broad array of GDPR obligations once it applies, ranging from stringent data breach notice obligations, record-keeping obligations, where for each data set you have to maintain what are the data attributes, how do you use it, when do you delete it. We never delete is never the right answer in the EU, by the way. So it's a little different. You have mandated terms in those processor agreements. Won't go into these, but I just want to let you know there is a broad array of obligations if the GDPR does apply to a data set. This slide just identifies if you're marketing, you have an awful lot of data sources, and the GDPR will apply to all of them. Personal data is personal data. Whether you obtained it first in your business relationship or you bought a prospect list, query, you have to be very careful in buying and using a prospect list in this new world, or if you're getting it from surveys and the like. So it's not a narrow concept in terms of where you might find personal data and have to apply the rules. Now to get into the meat a little bit on consent as a legal basis. And consent is one of the legal bases that applies in the EU today. It's several bases, but under the GDPR, the consent rules became much stricter. The technical rule I've sort of paraphrased here: an affirmative action freely given, specific, informed, and unambiguous indication of the data subject's wishes. Data subject is the word they often use for the consumer or the person. And there's a lot buried in those terms. Consent implies choice. There has to be genuine choice for the consent to be valid. So there's no take it or leave it mandatory consent. You could have a valid mandatory consent only for uses that were necessary to perform the service or contract, but then you don't even need consent for that. There's the alternative legal basis. The consent cannot be bundled and buried in a broader contract or set of terms. It can be in the same document, but it has to be prominent and has to have a separate expression of consent. And then certainly pre-check tick boxes or silence cannot constitute consent. There's no implied consent. And there's more. Consent has to be as easy to withdraw as it is to give. So you always have to be sure that your systems can accommodate somebody withdrawing consent. And then a separate consent, or at least expression of it in the document, is required for each type of plan processing. Today, in the terms and conditions, we often have something like, we will use the data to provide services to you, to tell you about other products that might be of interest, to develop new products, and so forth. Each one of those is a different type of processing. And that would require, 3 or 4 different types of consent expressions within a given document. Then here, no grandfathering. If you've got a legally valid consent already under the EU, but it doesn't meet the new standard, starting in May of 2018, that will be an invalid consent. And that leads to some tactical decisions. And I also note that I said consent needs to be informed. There's some very detailed notice obligations under the GDPR where you have to go and publish in detail, typically in a published separate notice, how you're going to use the data. And that has to be fully compliant too for the consent to be valid. It's not just have the separate prominent consent. So, a couple of tactical comments here. I mentioned that if you have valid consents today, they may not be valid if you don't meet the new rules. So today you can use them to seek out GDPR compliant consents from those EU customers. Keep your marketing contact list or database valid and usable. You might not have the right to do that after May of 2018. And indeed, some firms who are just trying innocently to update their consent contact list within the last few months were fined in the UK because it turns out their consents weren't even valid under current law and they couldn't prove they had them. So they were just trying to clean up their list and be compliant, and they got a fine for it. And that will apply even more unambiguously after May of next year. Second, as in Canada, the burden is on the controller, the marketer. If you obtain valid consents, you have to prove you have them. You can't say our general practices is the following. You have to say, here's the consent language, here's what we have, here's our records. Now I note here that there are some possible variations in the consent rules in a B2B context. We don't think that will be likely. It may be likely in another set of parallel laws, but it's not crystal clear what the rules are when you're contacting an employee of a business. Most likely, your basis for contacting that employee of a business customer is going to be the so-called legitimate interest basis that I'll touch on, not consent. Because you probably won't have a consent from every employee of a big customer, certainly. One of the parallel regulation that I mentioned is the e-privacy or e-privacy directive, which is now going to become the e-privacy regulation, which means it will have the force of law. It is available in draft form, came out in January, and it's currently being debated. And indeed, came out, I think, from the EU Commission. Now the EU Parliament's looking at it, and they just marked it up. And I was told last night they've distributed it to the members of Parliament. That means it will be leaked within days, and so we'll get a good look at it. I don't have a copy yet, but we'll see how different their proposal is from the current draft. And it matters because the e-privacy directive applies to electronic communications, electronic marketing communications in particular, email, calls, texts. And the GDPR still applies. You need to have that underlying consent to use data or legitimate interest. But this is an overlay of what are the rules that apply to email and so forth. And currently, they would allow a soft opt-in. Otherwise, you need actual consent before you send the email. But they would allow a soft opt-in if it's an existing customer and you're marketing similar products or services, and you include an opt-out when you collect the data and in every subsequent email. But even this soft opt-in is being debated, and so we'll see where they end up. And there also is discussion of should this be an area, B2B in particular, where they allow country-by-country variations. Because today, some of the countries in the EU basically allow an opt-out approach to B2B emails, and others are very strict opt-in. So more to come on that. The problem with the e-privacy directive is that it's not final, may not be final till early next year. People are growing concerned whether it'll be final and in effect in May of 2018. But that certainly is the target of all the politicians. So this doesn't prevent you from doing GDPR homework and preparation if you think it applies, but it may affect the timing of when you actually plan. What's the language of my email and my exact email strategy going to be, and what will it look like? Touch briefly on legitimate interest, which is a distinct legal basis, kind of open-ended, but that makes it really useful. A lot of businesses in the EU are moving away from consent because it is so onerous and relying more and more on legitimate interest for using personal data and in particular for marketing. Legitimate interest basically says, I want to use it in my own legitimate business interest, and I've done a balancing, and the impact on the data subject is minimal, or if it's outweighed, and I've tried to reduce any negative impact, and therefore I should be able to use it. Very open-ended. The problem is you can't be super confident that you'll be upheld by a regulator, but if you are, it's much less burdensome. The consent rules are strict, but if you follow them, then you know you have valid consent. In the recitals to the GDPR, which are sort of like the official legislative history, they say legitimate interest can be a legal basis for direct marketing. They don't say to existing customers, the way I say in the slide, but that's the way most regulators are starting to read that comment, because they want you to have some kind of relationship to the individuals where you use legitimate interest to send them direct marketing. And we've also had regulators informally tell us in discussions that sure, it can be used for direct marketing, but if you're doing some very intrusive, personalization-driven marketing where you're monitoring your customers' behavior and targeting the ads based on that, you're going to probably need consent from the individual or perhaps from the business. But that's not the law today, but that's what they are telling us. So bottom line, what do you do today if the GDPR might apply? If it might apply, or you think it does, even if you cannot fully flesh out the draft forms, your emails, and the opt-out notices and the like, you can at least identify, do you have EU personal data? It's not just data on citizens, it's residents of the EU. How do you have it? Where do you store it? Who has access? How is it used? Do you have any consents? Do you apply any data disposal rules to it? Do this homework, and then you'll be ready to comply. Because this homework sometimes is the biggest part of it. If you have it and it turns out it's held by a vendor on your behalf, that triggers some vendor-related obligations. If you have it and you have it under some old consents, maybe you want to consider updating the consents, which you can do now. You know the rules there for the most part, even though you're not sure quite what the email rules will be like. So there's certainly some homework that can be done. The other point I make here is you have to sort of come to grips with the concept that under the data protection rules that apply today, but more so under GDPR, the whole concept of data minimization, only get as much data as you actually need and need to use. Don't collect it because it might be useful, and don't keep it beyond the period that you need it. Is really at odds with what good marketers do. They want data maximization so they can use it today, next year. And you have to sort of draw a balance there because data maximization is not the rule of thumb. And that sort of is my issue spotting, high-level GDPR that didn't really probably help you comply, but at least gives you a framework as you follow some of the developments over the next year that come out of the EU.
Thank you so much, Mike. That was really informative. As a marketer myself, both Julie, both yours and Mike's presentation hits home for me. So I really do personally appreciate you joining us today. We're going to address everyone's questions in a moment. Please remember to submit them using the questions panel in the GoToWebinar box. And as you do that, I just like to provide you with a couple of reminders to give you a little bit of time to add any additional questions. And links to everything that I'm reviewing will be included in the PowerPoint presentation that will be included in the webinar follow-up materials. So first, don't miss out on any of the opportunities to grow with Interaction. Choose your communication preferences to receive newsletters, webinar invites, and product updates. This is particularly important if you're a U.S. customer and you didn't receive the invitation for this webinar through your email. That likely means that you will want to update your communication preferences. Mike, can you go to the next screen?
Yes. There we go.
Perfect. And Interaction continues to invest in your success, and we have a couple of big releases this year. So start prepping now for enhancements to Interaction Mobility, which is now included with for all Interaction customers. Interaction IQ, Business Edge. We have 7 new Interaction Core reports that are going to be going live later this quarter. And so for more information on the tools you have now, or to be the first in line to upgrade for our upcoming releases, make sure to reach out to your account manager today. And Mike, one more slide. Something else that's great that we're launching right now, our professional services team has just launched a brand new program that provides continuous access to our best and brightest to help you and your firm achieve its goals. And so you'll have a link to the brochure in the follow-up to this presentation, but also look out for an email with details on that. It should be going out tomorrow. Mike, if you could go one more slide, we'll go ahead and take questions. We actually had a great number of questions come in, so thank you so much for everyone being so engaged. So we're just going to go over a few of them before we end the webinar here. I've kind of separated them into a couple for Julie and a couple for Mike. So Julie, let's go ahead and get started with you. We have a question from Georgia who asks, if someone gives me a business card, how long can I contact them by email, and how do I track this?
Sure. So for obvious reasons, this is one that we utilize quite a bit here because, salespeople especially are out and about collecting business cards. So what you need to do if you do receive a business card is you need to, again, be able to track that you're using that, you're relying on that as the basis of sending a commercial electronic message based on implied consent, because that's what it is. It's a form of implied consent. So what you need to do is what we generally say is take a picture of the business card or scan it and upload it to if you have, I'm sure in Canada, because in Canada, as I said, we have the CASL tool, but in the US, I'm sure you use some sort of CRM system there, and I would upload it into that client's file and make a note saying the date you got it, the circumstances around which it was provided. And before you go and use that to send them a message, very similar to getting the email off the website, you have to make sure that the message that you're sending, the commercial components of it, are relevant to that person's business role or functions. So that's the big one. And I mean, then the obvious one is if they give you their business card and say, but don't email me, then obviously don't email them. But most of the time, that's not going to happen. So just make sure it's relevant and you have some sort of record of when you received it. And it will be, and the other thing is the 2-year rule applies there because it's implied consent. So you have two years whereas you can rely on that and hopefully have that implied consent transition to express consent within that 2-year period.
Great. And Michelle has a question. Can you be sued if you mistakenly breach CASL?
So this is a very relevant question right now, because when CASL first came out 3 years ago, part of it was what they call a private right of action. And what that would have allowed is to have an individual, or more likely a class action, a class of people, potentially sue companies for breaching the act. And that was in addition to the regulatory penalties that I showed you. And that was actually supposed to come into force on July 1st of this year. And literally at the last hour, maybe I'd say a week before that was supposed to happen, the government, again, it's actually a different regime in Canada than the one that enacted this legislation, so it's kind of understandable. They had a lot of pressure from businesses saying that there were some problems with that private right of action, and so they decided to delay it indefinitely. So that's one piece of good news on CASL, but no, at this point you cannot be sued.
Excellent. And Mike, I have a couple of questions for you. We have a question that came in from Tom. He wants to know if we determine that GDPR might apply to part of our business, what should we do right now? Should we wait for additional guidance that you mentioned? Is that the best course of action for now?
I think if you decide that it does apply, then learn more about that EU personal data that you hold. Focus on where is it held, how is it used, how did it get here. I would not necessarily jump to get the brand new consent immediately. Certainly consider it before next May, but there's clarification coming from regulators on what's a valid consent notice potentially. So you can't go forth and finish a compliance program, but you can learn about where's that data held, how is it held, do you really need it? Maybe you don't need new consents. Maybe you can use the so-called legitimate interest basis if that EU personal data is just existing customers and you're doing some very simple, straightforward marketing.
And Mike, I'll start this question with you. We had a couple people that asked about this, and it's possible, Julie, that you might want to chime in if there's anything to add. Mike, how are GDPR rules different from CASL? Because they sound somewhat similar.
They both have concepts of strict consent in them. In the end, unless they come up with some B2B exceptions, the consent rules are very strict with no implied consent, but then they have that alternative in the back pocket, legitimate interest, particularly for existing customers, that lets you market to existing customers on the basis of legitimate interest. One of the caveats there, they say that if a customer ever objects to being marketed on the basis of legitimate interest, or frankly on the basis of consent, they have that absolute right and you need to stop marketing to them. So that's one of the key differences. On the consent four corners, no implied consent, but they have that other almost an escape clause of legitimate interest.
And Julie, do you have anything to add to that, or does that sum it up from your perspective as well?
Yeah, I think we'll have to wait and see as well. I mean, I agree with everything that was said, but we'll have to wait and see how it all plays out, because as Mike mentioned at the beginning, CASL is a legislation that's been around for 3 years now, so we've actually been able to see how it's been enforced. But with GDPR, you're still getting a lot of clarification, and it seems like GDPR could be more broad in its application, because CASL doesn't really focus on the concept of personal data, personal information. It's only about an electronic recipient's contact. So even when we track it, for example, we're not tracking consent down to the individual level. We're tracking it to the email address or to the text number. So it's a little narrower in scope, I'd say, in that respect.
Great.
One nuance under GDPR is all the non-marketing stuff, mandatory detailed record keeping and so on, all of which can be audited by regulators and big fines if you don't do it. That's very onerous, And I know that we were talking about records in Canada so that you can comply. The record keeping under GDPR is just mandatory, not just for compliance.
Excellent. And I wanted to recognize that we did have a couple of questions that were more about interaction tracking when it comes to CASL and to GDPR. And so we'll definitely follow up with you guys individually because Julie and Mike don't work directly with interaction, so I won't be able to get your questions answered today. But I know Kevin, Everett, Amber, your questions, we'll definitely follow up with you guys with someone, a member from Interaction, that'll be able to help you a little bit better. And then I just also wanted to let you guys know there's a couple more questions that had come in. Angela, Kevin B, there's a couple more, Sharon. So we will definitely, the questions that we didn't get to today, I see one come up with Jason as well. So we'll make sure, I'm in the future, I'd like to see what other kind of information we can get together for Interaction when it comes to these regulations. So just wanted to give you an FYI on that. And really just in closing, I just wanted to thank you guys for joining today and just being as engaged as you are. I know this is both of these are very important topics. And again, I really appreciate Julie and Mike, you spending the time with us today. And as you exit, everybody, a brief survey will appear. And I'd love to get your feedback about today's webinar and then also suggestions for future Interact with Interaction webinar topics. And I'll be happy to incorporate those. So thank you so much and have a great afternoon.
Thank you.